I think what's important is to make your language clear to the user. One of the defenses to violating a contract could be, well, I didn't understand it in the first place, or I didn't know that that's what that meant by that. So if you can automatically, counter that with, but it was written so clearly, so you really can't entertain the argument of, I didn't know that I would be kicked off if I violated.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Neda Al-Nejafi, lawyer and creator of Contract Nerds, tears down the Twitter Terms of Service. This document has been in the news a lot lately, with politicians and celebrities removed from the platform for violating its rules. Drafting a Terms of Service document that gives a platform like Twitter the flexibility to operate and self-edit is no easy task. And Neda shares important principles for threading that needle. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show. I'm Mike Whalen. On this show, we do exactly what the name implies. We take contracts and beat them up with rage and fear. I bring on smart friends like Neda Al-Nejafi, who is here to talk to us about a hot topic. And we're going to try not to get in trouble. Neda, how are you today?
I'm good, Mike. How are you?
I'm okay. I'm feeling a little... Okay, it's not our fault, okay? That before any of you start writing us emails and text messages and comments below, I didn't create this situation. We're just talking about a contract. Relax. The contract that we're talking about is this one. The Twitter Terms of Service. And specifically, we're going to dig into how someone who, might be president could get kicked off of Twitter according to their Terms of Service. So we're going to roll through this thing. Neda, why are we talking about this? What is in this moment? But also, as contract drafters, why is a Terms of Service a useful document to talk about for the companies that we represent?
Great question. Well, every single website anyone uses usually has a terms of use. And it is simply a contract between the website provider, which here is Twitter, and the user. And Twitter has, last time I checked, about 330 million users. So this agreement applies to all 330 million of them. So I think it's a little important to check out what's actually in the terms of use.
Yes, and I'm talking to you about this. I want to know why. Tell the viewers a bit about yourself, about your background, and how you're coming at this Terms of Service document.
Yeah, so I have been an in-house attorney for about 12 years now. I'm currently in-house at Franklin Templeton, but nothing I say on this video is ever representative of Franklin Templeton's opinion. It is simply my opinion as Neda Al-Nejafi, so just want to make that clear. And I love contracts. I love negotiating contracts and dissecting them. And I really love your show, Mike. And I figured this would be a great contract to talk about, given all the chatter in the news recently.
The hullabaloo. Lots of opinions on both constitutions and contracts out in the world. We're going to try to avoid most of that drama and first start by talking a bit about the technicalities of this document. So, Neda, if you'll go with me, I'm going to roll down to Section 5 on this document called the Disclaimers and Limitations of Liability. There's talk about the services being as is. It makes no warranties. But then down in the limitation of liability, there's that famous all caps section. It says basically nothing is our fault. And specifically, it says, in no event shall the aggregate liability of the Twitter entities exceed the greater of $100 or the amount you paid Twitter, which is zero. Talk to me about that section, about this cap of liabilities. Is this going to work?
Yeah, so they basically want to completely limit their liability in terms of the types of causes of action that users can sue them for in civil court. Why? Because they don't want 330 million users suing them in court every time they get unhappy about something. Now, when we look at the limitation of liability language, the stuff in all caps, That's pretty standard. But when we get to the limitation of liability cap, which is $100, that to an attorney who sees a lot of contracts could kind of take one aback, and you could kind of think, wow, that is really low. But we do have to remember here that Twitter's offering this service for free. So when it comes down to it, it's really up to you as a user to decide, do I want to use Twitter and take on this risk that I will not be able to sue them in court if I'm unhappy? And if I do, the max I'm ever going to get is $100. That's
Right.
something to think about.
Yeah, and it's got the word herein in there, so it's legally. I'm jumping down to 6 now to this general section. It talks about, anytime you've got these terms of service, these things change, right? We get these emails. None of us read them. We're just hitting delete. My wife always makes fun of me because I don't read documents that are put in front of me, and I always say their lawyers are better than mine. But under general, it says, we may revise these terms from time to time. The changes will not be retroactive. The most current version of the terms will be on the website. We'll send you an email. Talk to me about, does this cover their requirements in terms of letting people know what the changes are?
Yeah, absolutely. And, most people probably don't review the terms of use of these websites until they're upset about something didn't go their way. And then they scroll through and they're like, what? They can make a change anytime they want. But the reality is, again, 330 million users, they can't send out notifications every single time they want to update their terms of use. That would be, from a practical standpoint, really difficult and expensive to manage. So they say they reserve the right to make changes at any time. They will try to provide notice if there's a significant or material change. That sometimes you'll get an email saying Twitter has now updated their terms of use. That may happen once a year or so. But in general, they like to keep up with the laws that are changing, whether it's a privacy law or some other type of standard that they want to go ahead and make that update on the website.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Well, now that we've covered sort of the safe stuff, let's jump to the drama. I want to point out on this document, whether you're talking about the content or canceling, there's this phrase that comes up multiple times. So let me point it out. Under content of services, it talks about we reserve the right to remove content that violates the user agreement. And it says, go down and look at the rules and the policies. If you look again further down in 4, please review the Twitter rules and policies. This is how you have to use this thing. We may also remove or refuse to distribute any content on the service if it violates these Twitter rules and policies. You keep going under the ending of the terms. Don't violate the rules and policies. So what we know is in this document, there's a bunch of references to another document. Tell me, as we shift to the newsiness of the moment, why is that relevant? Why is pointing over to this other document outside this one relevant?
So the terms of use itself is more like the legal terms and conditions. The rules and policies that they're referencing to is more like the moral compass of the company. What does Twitter want to be known for in terms of their beliefs, their branding? What do they stand for as a company? What will they accept? What will they not accept in terms of behavior and conduct? And some of these concepts are more left to the subjective mind. Like, does it feel wrong? Does it feel that it is offensive? And that's where Twitter points to the rules and policies, which is on a separate URL, so that they can always update that and modify it from time to time. And if you violate one of these rules and policies, which Twitter has pretty broad discretion to decide on, then you violate the terms of use, and therefore you can be permanently suspended.
Right. And we'll talk structurally about the relationship between those documents at the end when we try to address the principles, because we're really trying to help attorneys who are having to draft this kind of thing. But I do want to address sort of the what do they say? The elephant in the room? The elephant in the room. The guy might have a monkey with him, but it's this document. It is a letter that Twitter issued about the permanent suspension of the account at Real Donald Trump. And what they talk about in the beginning, going back to the rules of, that moral code that you talked about for Twitter, they said, after close review of recent tweets from that account and the context around them, specifically how they are being received and interpreted on and off Twitter, which is interesting, we have permanently suspended the account due to the risk of further incitement of violence. And if you go to their policies that they reference, they actually send a link over to this document, this glorification of violence policy. It says you can't threaten violence, but you also can't glorify violence. There's not a lot of specificity in these. I mean, there are a lot of words, right? There's about protected classes, but talk to me about how Twitter used this moral code to make a decision about what was a very politically heated question.
Well, that's a good question. I don't know how Twitter, landed on using this specific policy to cite as the reason that they permanently suspended Donald Trump. But from the way it's drafted, it looks like the drafter purposefully drafted the language to be broad, so that there was room for subjective interpretation. Number one, so that Twitter has sole discretion at the end of the day, whether someone can be a user on their platform or not. And that's from a legal and business standpoint within their right to do so. But also because these are very difficult concepts to define kind of in a static way. They are dynamic. The ways that you can abuse someone has changed from 100 years ago to now. Now there's online abuse. There wasn't that before. If you were to have crafted a definition that didn't include it, you might unintentionally exclude something. So they want to leave it broad enough so that they can exercise their discretion. But what Twitter did here was they wrote a letter to the public stating why they made that decision. And they cited two posts in particular that they believe violated the glorification of violence policy, which they didn't have to do. They didn't owe a duty to do that per their terms and conditions, but they did that voluntarily.
Yeah, and I think this is an interesting example because A, it's just drawing interest right now for obvious reasons, but B, because you see the business use case, right? And for a lot of attorneys that are drafting these kinds of documents, we talked about this with Colin Levy with Boston.com's terms of service in a similar vein. There's not a lot of control that these companies have over the content that's put on these sites. And so they seem to sort of have this policy of, we're going to create the ability to clamp down, but not the requirement to clamp down. And my sense is, and correct me if I'm wrong, by doing these sort of two separate documents, one that's this terms of service, here's what we're required to do, and over here the rules, this moral code, that seems to create this sort of semi-permeable wall, right? That they can, like, I'm just thinking structurally, what's the structural advantage of putting it in two separate documents as opposed to one? Is there one?
That's a really good question. The terms of use, you want to try to keep it focused on the legal duties and liabilities versus the rules and policies is more around company culture, branding, and, the moral compass that we talked about. Each one has its own way of being dynamic and should and can be updated from time to time. I think a lot of it was due to organizational reasons, keeping them separate, but also from the user standpoint, so the user can understand, hey, maybe I don't understand or want to read these long legal terms, but I do want to know what I can and can't do from a practical standpoint. So I can go over here to this link instead.
Yeah, I'm noticing fewer herein's and heretofores and therein such and suches in the moral code. But it is an interesting thing because you saw with Twitter, obviously before they pulled President Trump's account, there were a lot of calls to pull President Trump's account well before this moment, and they never felt an obligation to do it. So to me, we're not making a judgment. Netta and I are not making a judgment about whether this is right or moral or even ethical or good for society. It's just a question of, can the business do this and how can they do this? And so I wanted to ask you, in terms of, if I'm the drafting attorney, if I'm somebody who's having to give, what I'm seeing here is that the business wants flexibility and also strength. What are some principles that I can pull from this experience, these documents? Do you think Twitter did this well? Is there some, lesson that a lawyer can pull from this experience that can tell them, here's how I need to do this well? Any principles you draw from this?
I think what's important is to make your language clear to the user. So however much you can reduce the hereins and the whatsoevers, that's going to be helpful, because one of the arguments that would be difficult to, let me say that again. One of the defenses to violating a contract could be, well, I didn't understand it in the first place, or I didn't know that that's what that meant by that. So if you can automatically, counter that with, but it was written so clearly, we gave an example, we said it 5 different times. If you read the Twitter terms of use, they reference their rules and policies 5 different times. And they say in 5 different ways, if you violate the rules and policies, you will no longer be able to be a user. So you really can't entertain the argument of, I didn't know that I would be kicked off if I violated these. So that's, I think, clarity in the drafting language is super important, and know who your audience is. They are everyday users from all around the world, coming from different cultures. They speak different languages. So make it as clear and concise as possible.
It's an interesting thing, though, structurally, because I'm thinking about as a way to accomplish this, right? Like, you as the lawyer, you have to have these legal checkboxes, and you got to have the language in there that keeps people out of trouble. Obviously, that's your job. But you're also trying to communicate something. You're doing a social nudge, to use a Cass Sunstein-ism. You're trying to nudge people into certain behaviors. What's interesting that I found about this, when I signed up for Twitter, at least when I signed up for it forever ago, I met Mike Whalen Jr. You guys can find me there. I therapize out loud there. But when I signed up for it, as I recall, it's links, right? So they give you the terms of service. They give you this very long legally document, and then you're supposed to click a link to go over to the public targeted, normal speak rules. I guess my sense is, if you're going to do this, maybe this is a principle, maybe this isn't. If you're going to do this and you're going to say, this is the jargon-free, clear guide for how to act like an adult on our space, then put that in front of people. Make them agree to it separately. Make sure that it's not a link that somebody has to actively go push to go somewhere else. I don't know how you feel about that, but I feel like, for me personally, I'm just going to scroll through the legalese.
Yeah, so you want it all right in front of you. I agree. I think that would be helpful, but also in general, your terms and conditions should be free of legalese to the extent possible. Of course, there's a traditional language that we have to keep in, like some things around limitation of liability or indemnification need to be phrased a certain archaic way for it to be interpreted the way we want it to by the courts. But otherwise, you're speaking to users, to regular everyday people. So even your terms and conditions should be very simple to digest. And if what you're saying is bring also the rules and policies in front of me, and maybe create a checkbox for those too. Not a bad idea.
Well, watch this space, everybody. Twitter just announced yesterday, we are recording this in January of 2021. I think 2020 just sort of has spilled over. But we are officially in January 2021, and Twitter just announced yesterday that they've got this new program, I think they call it Birdwatch, where other users can go in and score things that people have said for truthiness. If you'll notice, that sounds an awful lot like Parler's approach, which was a total disaster and didn't work at all. So all these companies are trying to figure this out. I'm assuming, I don't know if there's any legal strength to this, but I'm assuming maybe if they want to say, well, we acted fairly, maybe the public statements of all those people saying this looks like nonsense and here's the proof of it is useful to them. I don't know, moving area. I hope you guys will pay attention to that. In the meantime, Netta, if people want to get in touch with you, to follow you on the social spaces where you put all the appropriate disclaimers and say all the smart things, what's the best way to connect with you?
Yeah, I'd love it if you connected with me on LinkedIn at Netta Al-Nejafine. And you can also follow me at contractnerds.com along on the blog or on the Contract Nerds LinkedIn page.
Oh, I should show host privilege. I should ask you, what is Contract Nerds anyway? What are you up to on there? I want to make sure people can find that if they're interested, if they are in fact Contract Nerds, which if you're still watching, you qualify.
You probably are, yes. Well, Contract Nerds is the new home for everything contracts. It's a blog and a community, and we publish weekly blog posts every Wednesday straight to your inbox if you're a subscriber, all about contracts, contract management, contract negotiation, anything to do with contracts that a contract nerd would love is on the Contract Nerds website. So you can go to www.contractnerds.com. Thank you, cool. Mike, for the plug.
Absolutely. And we'll make sure that stuff gets linked in the show notes. You guys can access the show notes at lawinsider.com/resources. And if you want to be a guest like Netta, where we can pick on contracts, all you have to do is email us. We're at community@lawinsider.com. Thank you, Netta. We will see you guys on the next Teardown.